with a matter of reading Thomas and another Gospel NHS Foundation Trust.
Yes, Mr. Locke.
Good afternoon, my lord and my lady. I appear for Dr. and Dr. Abbasi. My own friend Mr. Quintavale appears for Mr. and Mrs. Hastrup, who are the second appellant. My own friends Mr. Miller, supported by Ms. Patterson, appear for the hospital trusts, who are the respondents. Well, this is our application for permission to appeal against the decision of the President, which I'm sure the court has read, and the court will understand the background facts to this, which are obviously a complete tragedy, but for both my clients and for Mr. Quintavale's clients. But stripping the emotion out of the case, this is a case which raises, we respectfully submit, some fairly focused and important points of law. The background, of course, as you will have seen from the papers, is that it's fully accepted that if best interest proceedings hadn't been commenced, there would be no basis on which the trusts could have applied to the court for an order to restrain the parents from naming the doctors, the clinical professionals of whom they were critical in the media.
I mean, it was accepted. Is it still accepted?
Well, as far as I'm aware, it's still accepted.
Is it still accepted as a matter of law that there is no argument that there could have been no freestanding claim?
It's not, but for the purposes of the hearing below, it's accepted.
Yes, but if permission were granted, would you accept it again?
For the purposes of the
Okay.
Well, my lord, I put a single sheet of paper on your lordship's desk, which I handed out this evening, which raises essentially 4 issues.
When you put things before my court, Mr. Locke, they are sent electronically or they're not looked at.
Oh, well, my lord, I was informed of that immediately before coming in. I can certainly...
I think it's pretty clear, actually, now.
It is, my lord.
Yes, we work electronically.
I apologise, my lord. If your lordship would possibly stretch a point...
No, you can tell me what you want to tell me.
Right. Essentially, stripped of the emotion, this raises 4 essential issues of law, 4 points of law I can make, which make the case of my submission. That the learned judge below is mistaken. The first point is that the High Court has an inherent parens patriae jurisdiction to protect children and the vulnerable, but that inherent jurisdiction does not extend to adults with full capacity. Now, I passed up this morning electronically, my lord, the Re-L case, and that makes the point very clearly, in particular at paragraph 53 of that case, where...
well, I mean, that proposition, where's that in your skeleton argument?
Well, my lord, it lies behind the skeleton argument.
Well, it's not in the skeleton argument.
Not in the skeleton. The reason...
Why don't we stick, Mr. Locke, to the points that you want to argue that are in your skeleton argument?
Because, my lord,
in
order to answer the point raised by my learned friend in his note of reply, I have to explain why Re-S doesn't assist him. The second point, my lord, which is in my skeleton argument, is how we raise the case below, is that the duty on the state to respect Article 8 rights does not of itself create any freestanding legal cause of action between non-state persons. And that's a principle which was argued below and is argued as authority for that proposition, can I take the court...
Well, you don't need to make good your authorities here. You say that's a perfectly arguable proposition.
And that comes from Venables,
Yeah.
a news we very know. And the key paragraph is paragraph 27, where that's what the former president says.
Venables quite a long time ago. There's a lot more authorities on contra mundum injunctions, to use a language that nobody will understand, injunctions against the world.
Yes.
Since then, isn't there?
There is, my lord, and I'll be coming to one of those in a moment. But the important point, my lord, is that all of those are injunctions concerning the exercise of threatened unlawful actions. And the essence of our case is that when Mr. and Mrs. Abbasi, Dr. Abbasi, want to name the clinicians, they are doing something which on the face of it is perfectly lawful. It's not suggested that it is a breach of any domestic law right. And in summary, my lord, my case is that the balance between Article 10 and Article 8 arises when the court is adjudicating between competing rights. In other words, the claimant has a legal right to keep some information confidential. The defendant wishes to publish, or the other way around. In this case, what Mr. and Mrs. Abbasi are being injuncted from doing is something which is not wrong in a legal sense. There is no legal wrong in them naming the clinicians.
No.
And the question is whether the
I mean, your stronger point, if I may respectfully say so, Mr. Locke, is that this is something the Court of Appeal ought to look at, because there is a difference of opinion between two presidents of the family division, and only one Court of Appeal decision that was really an application for permission and not a fully argued case.
Indeed.
I mean, that really is the nub of your argument, is it not?
The nub of my argument, but my lord, the nub of my argument, it is that, but my lord, it goes further than that, because essentially what we say is the power of the court to grant an injunction should only be exercised to stop somebody acting unlawfully.
Well, that's very interesting in the light of convoy collateral, where the power of the court to grant an injunction seems to be very general indeed. A case that might have been referred to by somebody.
Well, my
Since
lord,
it completely abrogates the Siskina and overrules the Siskina on which reliance is apparently placed. But your bigger point, Mr. Locke, and cutting through this, because this is only a permission.
of course it's only permission here.
Your bigger point is that this is a very important question. It's a question that hasn't received fully argued attention from the Court of Appeal in the light of modern family division practice.
Yes.
You say, well, that's at least, even if you can't overcome the hurdle of showing you've got a real prospect of success, there's some other reason why this ought to be heard, because it's time, at the very least, to look at Ward and the President's very comprehensive judgment together.
Well, my lord, I respectfully agree. I
mean, what else do you have to say? I mean, this is only permission. You don't have to. Don't have to argue the case.
I suppose, my lord, it comes to this. We put our application in on paper on the basis that we thought this raised important points. The matter was listed for oral argument.
It was listed for oral argument because it's a difficult question and an important question.
Yes.
And it's not always right to deal with important questions on paper.
Well, my lord, I understand that, of course.
The public are entitled to see the way decisions are reached, even for permission to appeal, in cases of great importance like this one and great public interest. But that I'm now concerned with whether or not you should get permission, and it seems to me that your best argument, if I may say so, is not is the one I've just adumbrated.
Well, my lord, I can't do any better than formulate it back to your lordship, which is that...
I think that unless my lady has any further questions, I think we'll just hear whether Mr. Quinterfell wants to add anything.
Lord.
lord, my lady, our ground one is essentially the issue that
It's your ground 1 and 2, really, Mr. Quintavalli.
that there is a conflict between approach from two successive presidents of the family division. It's a radical conflict, and there are disputes, there are differences on all sorts of different levels, and it is necessary for the Court of Appeal to determine which approach is correct. That's in essence.
So you say some other reason for an appeal to be heard.
Yes. I also say that once one looks at the approach in detail, and that I appreciate it's not something to be done today, that in fact one sees that the approach adopted by Sir James Mumby in A.V. Ward and in Reed J. a child is in fact entirely compatible with the trinity of cases, as my learned friend Mr. Miller calls them, of the House of Lords and the Supreme Court, which they rely on.
Well, you say it's compatible with VS, and the other side say it's definitely not. But you say at the very least, the Court of Appeal ought to be able to say which is right.
Yes. I'm able to show why they're compatible, but perhaps today's not the time to do that.
I don't think it is, you know. We've read everything that's been put in front of us and considered it with some care, Mr. Quintavalli. I mean, I think that, for my part, I'd like to hear from Mr. Miller. You just take your seat for a moment. Mr. Miller,
I was uncertain whether I had even rights of audience. It's all a bit grey.
You certainly have rights of audience. You've put in a very helpful document, two very helpful documents. And, you know, for my part, I find what you say very compelling. And I find what the President says very compelling. But my problem is this, that there must be certainty in the law. And in a situation where, as Mr. Locke and Mr. Quintavalli have said quite correctly, there is a difference. Well, the President expressly says that what Lord Justice Mumby, as he then was, and he obviously reiterated it as President, is wrong. And the Court of Appeal has only considered it in a permission application, not fully argued. And the jurisdiction question is significant and important, obviously, not only to this case, but to other cases like it, and to cases that may go further, and other cases where injunctions are sought against the world. Is it not a case where the Court of Appeal ought to be asked to consider the matter after full argument?
Yes, we wouldn't presume to suggest to the Court of Appeal that if the court sees some other compelling reason for taking an appeal, that shouldn't be the way the court should proceed. If that's the case, that's the case.
I mean, wouldn't it be more satisfactory? I mean, I'm not suggesting that you're definitely going to win, obviously, because there's an appeal. If there's an appeal, then the appeal will be entirely open. But it would be more satisfactory, wouldn't it, whoever won, for there to be a decision of the Court of Appeal clearly on point, than for there to be two first instance decisions which speak inconsistently, and for example, points to be taken saying, well, it shouldn't have been distinguished. What Lord Justice Mumby said is still good law in some cases when what the President said could be distinguished from it.
Yes. Well, you have our submissions. On the Abbasi appeal, the central point is obviously the one about jurisdiction. We say that's clear-cut because of the three cases at a higher level than this.
Yes, although the Article 6 you know, I mean, the jurisdiction question is not quite as clear-cut as the Abbasi appeal puts it because of convoy collateral. I don't know if you're familiar with that case.
Yes.
But that has thrown the Siskina upside down.
Yes.
That may or may not be relevant, by the way, to this. is, but at least it should be looked at, I would have thought.
Well, we would say there are three constituent parts to the jurisdiction. One is Section 6 and what that obliges the court to do. Secondly is the positive obligation to protect Article 8 rights, which is a convention law point. And thirdly, what can you do about it if you feel the Article 8 rights should be protected? Answer C, Section 37. So the higher courts have made clear that you put the three together and that forms the jurisdiction to determine this class of issue, the 8 versus 10 issue, where somebody is seeking an injunction. So really we say no point of law that's arguable there would have to go, we would have thought, higher for there to be any serious reconsideration.
We couldn't go higher if we refused.
Well, that thought has crossed my mind. So that there may be a reason to say that, but it's not a point of law. The question on the conflict between the observations of the two presidents is an interesting one, but the question is, what is it that needs to be considered? What is the point of law?
Well, the thing that bothers me, Mr. Miller, to be brutally honest, is the practice, the daily practice in the family division.
You can see that.
And if there is doubt about that practice, it's the job of the Court of Appeal. I see it as my job to deal with that. And then the practice can be entirely consistent and can be authorised by a higher court, whether it's our court or the Supreme Court.
And you have our point. It's a rather technical argument that's being raised against it in the Harstrock appeal. It's not a good point. Rios is clear. It's a fact-based jurisdiction. The judge will balance the facts on either side, 8 versus 10. There's no space for hard-edged rules in that process, and the attempt to inject rules into that process by the previous president, for example, you've got to have a vulnerable person or you've got to have compelling evidence, skews the parallel analysis, and it's wrong. And this president was right to say it's wrong. But I can see the importance, given the way in which these points get argued in the family division and court of correction on a fairly regular basis, to have a definitive ruling on that from this court, not on a permission application as in N, but in a full appeal. That's our position.
Can I put two things to you? One, I'm thinking that it would be anyway a good idea, if permission is granted, for you to consider your concession below that absent a free-standing claim under the tort of misuse of private information, the hospital staff would have no right to claim an injunction, particularly in the light of convoy collateral. And I mean, I'm not inviting you to say what your position would be on a substantive appeal, but I would propose to make clear that you would have the right to withdraw that concession. And I'll ask Mr. Locke, but I would also propose to make clear that while the President wasn't considering whether the jurisdiction existed to make the original reporting restrictions order in these two cases, I think the parties' arguments on appeal ought at least to be able to consider the juridical basis for that jurisdiction.
Yes, that is another loose end that is dangling there on the current judgment, and I can see the need to clear that up. May I say two things?
Yes.
Which are important.
Say whatever you want, Mr. Miller.
Well,
within reason.
Grateful. Given where we've got to, and they are both important. First, we are concerned about the wide-ranging nature of the appeals. There are a lot of points in there. And it seems to us that if some sort of permission is going to be given, they need to be narrowed down a bit. Second is the trust.
Is that, I mean, the reason why I'm doubtful about that is not because it's clear that in every point they want to argue, they have a reasonable prospect of success. But the reason I'm doubtful about it is it seems to me that every point they want to argue informs the wider picture, and it would therefore be undesirable. I mean, my experience of narrowing appeals is that it's always a waste of time, because people either come along and ask for permission again, or try and get round it in some other way. Whereas if you let them do their worst or their best, if you like, with every point they think they may have in their armoury, it's very easy to dismiss the bad points, much easier than if you haven't let them argue them.
Okay. Well, I've said my piece on that.
Okay.
I hear what you say. The other point is, and I'm certainly not saying it's inappropriate. I mean, I think Charles Dickens, all appeals are efforts by lawyers to make more work for themselves. I don't think that's the case here. I think these are genuinely thought to be good points. We just don't think they are good points. That's the problem.
Yeah.
But yes, they can be dispatched fairly easily. And as you know, our position is those 2 points that we've looked at as giving rise to compelling reasons for an appeal are the points with a bit of substance and compared with the others. The other thing I just wanted to say is the trusts are very concerned about how long this has all taken, and they're concerned on behalf of clinicians in particular who are closest to these cases. I mean, we can have adversarial discussion about, you know, the width of the injunction, how many people, the name, and all that sort of stuff. But there are some clinicians that are particularly close to these cases, and there is anxiety. That's the reason the trusts are pursuing these cases, and there is anxiety on their behalf, and the trusts on their behalf would like some finality, or as much finality as they can get in this matter as soon as possible. Not necessarily an application for expedition, but we just ask the court to recognise that and the fact that things have been quite protracted in these cases.
No, I completely see that. I'm afraid it's a function of litigation, isn't it? I mean, on the basis that I indicated, how long do you think the appeal could last?
Well, we did it in 3 days in front of the President. I would halve that at least in the Court of Appeal. Might be able to do it in a day, but certainly not more than a day and a half would be needed.
Okay, well, I'll hear Mr. Locke on that. Anything else you want to say, Mr. Miller?
No.
No, thank you for your help, Mr. Locke.
Well, a day and a half, I agree.
Well, I think I'm going to say 2 days, because a day and a half never means anything less than 2 days. And I think 2 days is fair for this.
Yep.
There may be quite a bit of authority to look at.
I think there might be more, but I will. On the question of resigning from the concession, my position would be that as long as we know what is properly formulated, and it is properly formulated rather than being an open concession invitation. In other words, if there is a cause of action going to be advanced, we know precisely what it is and what it's based on, then it would serve nobody's interest not to conduct the appeal on that basis. So I wouldn't oppose a properly formulated application if that's what the trust decide they want to do in due course. That may, of course, then raise arguments whether that raises an arguable case, but we'll deal with that as and when. The other point your Lordship raised was effectively whether the appeal should encompass interim injunction applications made, I assume, my Lord, in both court of protection and inherent jurisdiction cases, because those are the very similar issues arise both in court of protection and in inherent jurisdiction cases. Well, it must be sensible if the court wishes to look at that issue.
Well, it's not substantively looking at the issue. It's just that it should be open to the parties, it seems to me, to argue about the juridical basis for the grant of these injunctions at any stage. And the issue in the appeal here will only be the grant or extension of these injunctions after the death of the child. But that's the facts of this particular case. All I'm saying is I don't want you to be prevented from saying these injunctions, you can't decide this because it's not something that is before the court, but these injunctions should never have been granted for this or that reason, and are not appropriate because there is no jurisdiction. I don't know how successful you'd be in saying that, but all I want to make sure is that the court's not prevented from considering the full picture.
Well, I'm very grateful, my Lord. I suspect, I have to go and think about it, but I suspect it'll be a far more nuanced position on our side.
I expect so, yes.
Which is, these are appropriate purposes for which to grant injunctions to protect the confidentiality of the child, or to ensure that the proceedings can be dealt with properly coming up to a final hearing. And those are proper purposes, but those fall away once the hearing has finished, and therefore you have to look at it afresh.
Yeah,
In much regarding it that way.
I mean, I'm really concerned with what the President said in paragraph 2 of his judgment, when he said that there was no suggestion in this case that there had been no jurisdiction to grant the original injunctions. And I think that's obviously can't be challenged anyway because there was no appeal.
Precisely.
But the point is, you may want to say the jurisdiction has to be looked at, the original jurisdiction has to be looked at in this way, and therefore this follows or that follows. And what I don't want to inhibit is a full argument about the position of the court in granting these injunctions generally. Ultimately, the only decision in the case is going to be on the facts of these cases.
But we'll certainly look at, if I can call it, the before and the after, because the before governs injunctions given in one particular set of circumstances.
In one particular set of circumstances. And Mr. Quintavalle, if we read the President's judgment, argued or slightly shifted ground, it appears, towards the end of his reply of his submissions at the end. I don't know his reply or not, I can't remember. And the President said, well, I can't take note of that, but what I don't want this court to be in the position of is having been deprived of full argument.
No, but we will take that on board. We'll make sure that we address the before and the change, which is, I think, at the essence of our argument, and hopefully put the court in a position where it can see whether in stage 2 of this type of litigation it is appropriate to make continuing and what are in effect perpetual injunctions.
Yes. Okay.
Could I just raise one point about that concession? I think just to put down a marker. I'm very grateful for what Lieven has said. Misuse of private information has grown a lot in the last few years, as you know, and in these cases, one of the big issues was the knock-on effect of the naming and the criticism of the clinicians in terms of social media consequence. So other people then piling in, to use the vernacular.
Yes.
And that raises the issue, which Lady is familiar from the PJS case, of the overall impact on the person and their private life and family. It wouldn't necessarily be the case that we would be arguing there's a perfectly formulated cause of action against either the Drs. Abbasi or Mr. Harstrop. Wouldn't necessarily preclude the injunction or the existence of the cause of action, but it would have to take account, the court would need to take account of the fact that it would be other forms of misuse of private information that impact on the clinicians, rather than the initial discussion by the parents of the facts of the case, sort of consequences.
I think that's absolutely fair. Right. If nobody wishes to say anything else, I will give a short first judgment in relation to the applications before the court. Introduction. Dr. and Mrs. Abbasi's daughter, Zainab, who was born in June 2003 with a disabling neurodegenerative condition called Niemann-Pick type C. The Abbasi appellants disagreed with the treating Newcastle NHS Trust as to the treatment programme appropriate for Zainab. In August 2019, the Newcastle NHS Trust commenced proceedings for declarations that it would be in Zainab's best interests only to provide palliative care. Zainab sadly died 3 days before the hearing that was due to decide that issue on the 19th of September 2019. On the 10th of July 2019, Mrs. Justice Lieven had made a reporting restrictions order, an RRO, until further order, preventing persons, including the parents, from publicly naming anyone who provided care to Zainab at any time during her life. The order was partially discharged on the 31st of July 2020, but the parts referring to Trust staff remained in force. The parents applied to discharge the order, but the President refused that application in a detailed judgment handed down on the 23rd of June 2021. Mr. Harstrup and Ms. Thomas's son Isaiah suffered brain damage during delivery when he was born by emergency caesarean section at King's College Hospital on the 18th of February 2017. In early 2018, Mr. Justice MacDonald found that it was in Isaiah's best interests for treatment to be withdrawn. Isaiah sadly died soon after treatment was ended on the 7th of March 2018. An RRO had been made on the 6th of October 2017. That RRO still continues and prevents the naming of any of the Trust's treating staff. The President refused to discharge both orders that I have mentioned in the judgment I've also mentioned. He avowedly applied the balance between the Article 8 rights of the Trust's staff that treated Zainab and Isaiah respectively, and the Article 10 rights of the parents to freedom of speech, as described by the House of Lords in Re S 2005, 1 Appeal Cases 593, brackets Re S. In drawing the balance, the President referred to the adverse impact on the staff involved in the case of Charlie Gard, brackets Great Ormond Street Hospital versus Yates, 2017, EWH C 1909, and Alfie Evans, brackets Evans versus Alderhay Children's NHS Foundation Trust, 2018, EWCA Civ 805, and upon detailed evidence from experts to the effect that naming staff was detrimental to them and to the hospital's ability to deliver care to children. The grounds of appeal. I'm going to start with the first and second grounds of appeal in the Harstrup case, which are that the President was wrong in effect to hold that Lord Justice Munby had been wrong in A versus Ward, 2010 EWHC 16 brackets family brackets A versus Ward. The President said that a class of staff could be protected without evidence of particular vulnerabilities, and that A versus Ward was decided without proper account being taken of Re S and was wrong. Mr. Harstrup's submission, in essence, is that there is no incompatibility between A versus Ward and Re S, and that the courts should continue to approach with circumspection unparticularized class claims for anonymity based on general evidence. Compelling reasons should, he argues, continue to be required. Mr. Harstrup submits that the Court of Appeal's decision in Re M, brackets declaration of the death of a child, close brackets, 2020 EWCA Civ 164, supporting the President's view, is to be given less weight because, one, it was an unsuccessful permission application, two, the facts were unusual in that the child had already died, and three, the Trust conceded that the anonymity order should extend for only 28 days after the withdrawal of ventilation, brackets see paragraph 104 in Re M. Mr. Harstrup's main point, however, is that A versus Ward concerned a balance between Article 8 and Article 10 and Article 6, whilst Re S did not. It seems to me that it is appropriate for the Court of Appeal to consider on a full appeal the modern practice of the family division in granting indefinite anonymity orders to a wide range of medical staff in cases of this kind. This needs to be considered also against the background of the law relating to other injunctions granted against the world, bracket C, for example, Venables versus News Group, Newspapers, 2001, Family 430. For the avoidance of doubt, I do not think that the respondents should be held to any concession below that absent a freestanding claim under the tort of misuse of private information, the hospital staff would have no right to claim an injunction if there were no other extant proceedings, bracket C, paragraph 39 of the President's judgment. And whilst the President was expressly not considering whether the jurisdiction existed to make the original RROs in these two cases, bracket C, paragraph 2 of his judgment, and that cannot therefore be the subject of the appeals, I don't think that the parties' arguments should be prevented from considering the juridical basis for the jurisdiction that was being exercised. The other grounds of appeal in Haarstrup are connected in that they raise the questions of, first, whether the President properly applied Article 10, secondly, whether the parents needed to say what they wanted to say about staff before their applications could be considered, and thirdly, whether the President impermissibly departed from the open justice principle. The grounds of appeal in Abbasi raise the question of whether the President omitted to consider whether there were any proceedings in which the injunction could properly be granted or continued, relying on Section 37 of the Senior Courts Act 1981 and the Siskina 1979 appeal cases 2010. These arguments, as it seems to me, fail to take account of the Privy Council's recent decision in Convoy Collateral versus Broad Idea International, 2021 UK PC 24. The Abbasi appeal also raises the question of whether a claim under Article 8 can amount to a freestanding cause of action, whether the orders made breached Article 10, and whether even if the injunctions might have been correctly granted in the first place, they could or should have been continued in the present circumstances. Conclusions. I would not wish to comment on these additional claims, the ones that I've mentioned, in the light of my view that at the very least there is a good reason for the Court of Appeal now to consider the legal position affecting the appropriateness of a general order allowing all treating staff of a particular NHS trust anonymity in these circumstances. To be clear, whilst I find the President's reasons compelling, and I mean no criticism of his judgment, I think for the reasons that I've tried very briefly to outline, it's time for the Court of Appeal to consider the questions raised by these two very sad cases, by A versus Ward and by Re M, in the current context, including the new approach to transparency in the family division. For these reasons, I would allow permission to appeal on all grounds, since little extra time will be taken up by the additional arguments, which will themselves give context to the central points that I've adumbrated. In these circumstances, I would invite the parties to agree directions for the filing of sequential skeleton arguments, taking account of the indications given in this judgment.
I agree.
Well, then can we ask you to do that? I have in mind that, bearing in mind that the appeal will now go ahead, and it'll be a full appeal, you may want to reconsider your permission skeletons. And in the light of the discussion we've had, the useful discussion we've had this afternoon, I would suggest, Mr. Locke and Mr. Quintavalle, that you put your, sorry, I'm mispronouncing your name, aren't I?
No.
Am I not? Okay, good. I would suggest that you will want to put in a revised skeleton first, and then the respondent will want to put in their skeleton in reply after they've had a chance to consider your position.
Of course. Would your Lordship be able to give us any idea of when this matter is likely to be listed, and then we can work back from that to agree a timetable? I know what.
I think you ought to assume it may be listed in July, but I am not certain it will be.
Right. Well, I'll have a
But
discussion.
I think the skeleton should be in ready for a hearing in July if we can manage it. For the reasons Mr. Miller has given, it would be very desirable for it to be heard as quickly as reasonably possible. I'm a little pessimistic about that because I fear there may be, what should we say, a fairly powerful court wanting to hear this, and the availability of that powerful court will be needed to be taken into account.
Well, my Lord, the pressure on the list and the pressure on the judges is fully accepted, but we will endeavour to make sure we agree a timetable so that if it can be listed in July, we certainly from our side will be ready.
Thank you very much. Thank you. That concludes this hearing.